Okay, let's unpack this. We are diving incredibly deep today into um, a legal battle that really has ramifications far beyond just the companies involved.
Yeah, it's not just about who owes what. It's a fight that could, fundamentally reshape how you personally interact with artificial intelligence.
And we're zeroing in on one of the most sensitive areas,
Yeah.
your privacy. We're focusing on the ongoing legal showdown between OpenAI, the ChatGPT folks, and the New York Times.
Right. And look, the foundation of the New York Times' lawsuit is copyright. They're accusing OpenAI of using millions of their articles without permission to train its AI models.
That's the core claim.
It is, but actually, that's not the specific tension we're really drilling into right now. It's the engine, sure, but there's a specific demand from the NYT that sparked this whole separate, massive debate.
And what's that demand?
They want OpenAI to be forced to indefinitely retain every single conversation you have with ChatGPT.
Wow. Indefinitely. So think about that for a second. Everything question you've asked it, every, idea you've brainstormed.
Yeah. Sensitive topics you might have explored.
Yeah, exactly. And that demand, it just runs completely counter to what I think most people assume about digital privacy, right?
Absolutely. And it crashes headfirst into OpenAI's stated position on user privacy, which in turn led them to introduce this really fascinating and frankly pretty contentious idea they're calling AI privilege.
Right. AI privilege. We'll definitely get into that.
So our mission here in this deep dive is basically to pull out the most important bits from the source material you've shared with us.
Okay.
We want to understand the precise arguments from both sides, from the New York Times and OpenAI, specifically about this data retention demand.
And then analyze the potential impact. Because it sounds like it could be pretty significant for users.
Oh, profoundly. Very real impact on you as a user. And then we need to explore the much bigger picture, this whole burgeoning question of confidentiality in the age of AI.
Because, yeah, as we start peeling back the layers here, you can see it's way more than just some simple legal squabble.
For sure. It's complex. It touches on fundamental questions about what digital privacy even means when you're interacting with something that isn't human.
Like the very nature of these conversations people are having with AI systems, they seem to be treating them more and more like confidants,
That's a huge part of it. And then, of course, you've got the powerful corporate interests on both sides, vying for position, for control in this rapidly changing digital world.
Okay, so let's start at the beginning. How did this all kick off? The lawsuit itself.
Right. So the New York Times filed this lawsuit back in December of 2023.
Okay, end of last year.
Yeah. And it was against both OpenAI and Microsoft.
Why Microsoft?
Well, Microsoft is OpenAI's biggest financial backer, a
Yeah.
huge investor. And they're a key partner in distributing the technology, like integrating it into Bing, Office, that kind of thing. So they're looped in.
Got it. And the main accusation, as we said, is copyright infringement.
Primarily, yes. The NYT claims OpenAI just hoovered up millions of their articles, their journalistic content, to train its large language models, the tech behind ChatGPT.
Without asking, without paying.
Exactly. Unauthorized, uncompensated. Essentially, they're saying OpenAI built its AI using the NYT's expensive-to-produce journalism.
Okay. And what's the specific harm the NYT claims resulted from this alleged copyright infringement?
Well, they argue that because the AI was trained on their content, the models can sometimes spit out output that directly quotes the NYT.
Like verbatim.
Sometimes, yeah, or closely paraphrases it, or relies really heavily on the NYT's original reporting and writing.
I see. And the Times' fear is?
Their fear is that users will just get the gist or even the specifics of their paywalled content directly from ChatGPT without ever clicking on an NYT link, without subscribing.
Which would undermine their whole business model.
Precisely. Their model depends on the value and, well, the exclusivity of their content. If you can get it free from an AI, why pay?
Okay, that makes sense as the foundation for the copyright suit. But let's pivot back to the demand we're really focusing on today, the one that comes out of this lawsuit.
Your procedural one.
The request for indefinite storage of all ChatGPT conversations.
Exactly. So, as part of the normal legal back and forth called discovery.
Where both sides ask for evidence.
Right. Standard legal process.
Mm-hmm.
The New York Times formally asked the court to order OpenAI to preserve and retain every single chat log from every user since ChatGPT began.
Wow. Every single one. That's a staggering amount of data.
Billions, potentially trillions of interactions. They want a complete, unfettered look at the entire history of user interactions.
And why? What's the NYT's justification for needing all of that? It seems incredibly broad.
Well, from their perspective, it's purely about evidence. They believe that somewhere, buried deep within those mountains of chat logs, they'll find the smoking guns.
The specific examples.
Concrete examples where ChatGPT's responses directly reproduced or summarized or were clearly based on specific New York Times articles reporting.
Okay, and those examples would then be used in court to show the copyright infringement actually happening, to prove the AI did output their stuff to users.
That's the idea. They need the data to prove their case. It's their path to demonstrating the alleged harm.
So in one sense, it's a standard legal tactic, right? You ask for the records you think contain proof.
In principle, yes, seeking relevant data is normal, but, and this is a huge but, the nature of this specific data, private user conversations, and the scope of the demand indefinitely retain everything creates this immediate, incredibly sharp conflict.
A conflict with what?
With how OpenAI currently handles user data, especially when it comes to deleting chats. This is where the privacy alarm bells start ringing loud and clear.
Okay, let's break that down then. What are OpenAI's current policies? If I, as a user, delete a chat right now, what happens to that data?
So OpenAI has this multi-step process. They say it's designed to give users control and eventually permanently remove the data.
Okay, step one.
Step one is simple. User deletion. You're in ChatGPT, you click delete on a conversation in your history. Boom, it vanishes from your personal view, from your chat list.
Right, which, let's be honest, feels like deleting it, doesn't it?
Yeah.
That's the user expectation. When you hit delete, it's gone.
Exactly. That's the UI experience, designed for that immediate sense of control. But technically, that's just stage one.
Okay. What happens next, behind the scenes?
Behind the scenes, OpenAI's policy kicks in a waiting period. It's typically around 30 days.
30 days.
Yeah. During that month, the conversation data is actually still on their systems, but it's flagged, marked for deletion. It's kind of in like a digital purgatory, scheduled to be permanently removed, but not quite gone yet.
Okay, so it's not instantly vaporized system-wide the moment I click delete, but there's a definite clock ticking down to permanent removal, like putting a file in the recycle bin before you empty it.
That's a pretty good analogy, yeah. And then comes the final crucial step, the system purge.
The purge. Sounds final.
It's intended to be. After that 30-day waiting period is up, or around that time frame, the data is supposed to be completely and permanently wiped from OpenAI's production systems, their backups.
Meaning even OpenAI themselves can't get it back easily.
That's the goal, according to their policy. After the purge, the conversation data should be gone for good, no longer accessible or recoverable.
Okay, and this entire process, user delete, 30-day wait, system purge, is precisely what the New York Times' demand would just stop, override completely.
Absolutely halts it, dead in its tracks. The court order the NYT wants would fundamentally force OpenAI to stop this permanent deletion process.
So they'd have to keep everything.
They'd be required to retain all conversations. And crucially, this includes conversations that users like you have actively deleted from your view, the ones that would normally be purged after 30 days.
Wow. So my act of deleting becomes meaningless in terms of permanent removal.
That's the core of the privacy conflict here. The NYT demand isn't just about storing future chats. It's retroactive, covering the entire history, including data that OpenAI's own policies promise will be permanently deleted at the user's request.
It basically negates the user's control over their data after the fact.
Right, and forces OpenAI to hold on to information they publicly committed to getting rid of. This is the specific privacy violation that OpenAI is really pushing back against.
Which leads us neatly into OpenAI's defense strategy against this demand, and where they brought up this intriguing idea, AI privilege. What was their reaction when this data retention demand first surfaced?
Well, their initial reaction to the overall NYT lawsuit was pretty forceful rejection. They put out statements calling the claims baseless and without merit.
So they dispute the whole copyright infringement premise.
Vigorously. But their concerns about this specific data retention part seemed to go beyond just the copyright argument, didn't they?
Absolutely. Their CEO, Sam Altman, he specifically called out the data retention demand as being, particularly problematic.
He voiced deep concerns about the privacy implications, said being forced to keep all user chats indefinitely would be a major violation of user trust.
And this is where he floated the AI privilege concept.
Yes, exactly. He publicly advocated for creating something like AI privilege to protect the confidentiality of user conversations with AI.
And he used that very specific analogy.
He did. It's quoted in the source material we looked at. He said essentially that talking to an AI should be like talking to a lawyer or a doctor.
That's a powerful comparison. It immediately brings to mind confidentiality, doesn't it?
Right.
Why is linking AI chats to lawyer-client or doctor-patient privilege so significant legally and conceptually?
It's hugely significant because in legal systems pretty much everywhere, those human relationships, lawyer-client, doctor-patient, are considered confidential and legally privileged.
Meaning the conversations are protected.
Generally, yes. They're protected from being forced into disclosure in court cases or other legal proceedings. A court usually can't make a lawyer testify about confidential client discussions or demand a doctor hand over private patient consultation notes. There are narrow exceptions, but the principle is strong.
And the privilege belongs to the client or patient, right?
Yeah.
So they can speak freely without fear.
Exactly. It allows for open, honest communication in sensitive situations. So by suggesting AI privilege, Altman is basically proposing that your chats with an AI should get a similar level of legal protection from being dragged into court.
Like a shield against compelled disclosure.
That's the implication. His broader point, as the source material lays out, is that people are increasingly using AI for really personal, sensitive stuff. Confidential information sharing is happening.
Yeah, you hear about it all the time.
And as that trend grows, Altman argues, society needs to figure out new legal and ethical boundaries to protect the privacy of these interactions. He's saying the old rules designed for human-to-human stuff or just static data haven't kept pace with how people are actually using AI now.
But let me push back on that a little bit because it seems like a tricky comparison. Is talking to an algorithm, however advanced, really the same as talking to a human lawyer who's bound by professional ethics, bar rules, maybe malpractice insurance, or a doctor who took the Hippocratic Oath?
That's a fantastic question, and it gets right to the heart of why this concept is so debated and, currently has zero legal standing.
What are the key differences that make it legally messy?
Well, first off, the AI itself, it lacks consciousness, right? It has no intent in the human sense, no ethical obligations it feels. The conversation is, at its core, a data transaction input, processing, output.
And the data physically exists somewhere, on servers.
Exactly. So who would even hold this theoretical privilege? Is it the user? Is it OpenAI, the company running the AI? Does the type of AI matter? Like, would a general chatbot like ChatGPT get the same privilege as maybe a specialized AI marketed specifically for, say, legal research or medical symptom checking?
Loads of unanswered questions.
Tons. And the legal system just hasn't addressed them yet. So Altman's proposal, I don't think he's necessarily saying it's exactly the same as talking to a lawyer. He's using the analogy to highlight the need for some kind of strong legal protection, given how intimate these AI interactions are becoming.
So it's more about sparking a debate, initiating a conversation about where those boundaries should be, rather than saying, ChatGPT is your lawyer now.
I think that's a fair reading. He's trying to get policymakers and the public thinking about it. And did other OpenAI leaders back him up on this?
Yeah, the chief operating officer, Brad Lightcap, he also publicly supported this stance. He emphasized OpenAI's existing privacy commitments as part of their defense.
So they're pointing to their current policies, like the deletion process we talked about.
Right. Using that as proof that they do take user privacy seriously and arguing that the NYT demand forces them to violate their own established privacy safeguards.
Okay, so let's just summarize OpenAI's argument against this specific data retention demand. What's the nutshell version?
In a nutshell, they claim that complying would force them to abandon the privacy norms users expect, like the ability to have their data permanently deleted. They argue it fundamentally weakens the privacy protections they've promised to millions of users.
Got it. It's a direct threat to their stated user data controls.
Exactly. And this whole situation, it really throws a spotlight on what the source material calls a privacy paradox.
The paradox.
Okay.
Explain that.
It's this weird, complex reality of how people are actually using these AI chatbots now. It's often incredibly personal, right?
Oh, absolutely. Think about your own use, maybe, or stories you've heard. People are pouring out incredibly intimate details.
Personal problems, sensitive health questions they might be embarrassed to ask a human doctor.
Brainstorming confidential business ideas, writing deeply personal poems or stories, asking for advice on relationships, mental health.
The list goes on. And for a growing number of people, these AI systems are kind of stepping into roles that used to be exclusively human, or things you just keep totally private.
Like a pseudo-therapist.
Yeah, or a confidential sounding board, a trusted assistant for really sensitive tasks. And when you start confiding in any entity like that, human or not, you develop this expectation of privacy. Maybe it's implicit, maybe it's just hoped for.
That line between just using a tool, a utility, and having something more like a relationship with a confidant,
Yeah,
it's blurring really fast.
it really is. And that user expectation of confidentiality, plus the AI company's policies sort of reflecting that,
Right.
that clashes directly with a fundamental need in legal fights,
Which is,
the need for access to evidence through discovery rights.
back to discovery.
Right. The New York Times, as the plaintiff bringing the suit, has a legitimate legal right to ask for and get data that's relevant to their claims.
And if their claim is that the AI infringed copyright by spitting out NYT content,
Then the actual output of the AI found in those user conversations is arguably highly relevant evidence. Crucial even.
so the NYT isn't just being nosy or trying to read everyone's chats for fun. They argue they need concrete proof from the AI's actual interactions to show the court, look, here's where the AI used our copyrighted stuff to generate infringing answers for users.
Exactly. They need to find those specific instances within that massive pile of conversations where ChatGPT allegedly reproduced NYT text or analysis.
Okay, and this is where the collision happens, isn't it? Privacy protection, the user's expectation, the company's dilution policy smacks right into legitimate legal discovery rights the plaintiffs need for evidence.
Yeah. The case basically forces the question in this new digital territory, which takes priority. Privacy or discovery?
And a huge reason that's such a tough question to answer, as the source material really highlights, is the almost complete lack of legal clarity here.
Right. No rules specifically for this.
None. There is currently no established legal framework that specifically defines or protects the privacy rights around your AI conversations. We have laws and precedents built up over decades, centuries even, for human communications, doctor-patient, attorney-client, spouses, clergy confessions, that sort of thing.
But nothing yet for your chat with an algorithm.
Nothing specific,
Yes.
no matter how sensitive or personal that chat might feel to you.
So this lawsuit, and especially this data retention fight within it, is basically playing out in a big legal gray area. There's no existing law or clear past case that says, here's how you handle this.
Precisely. And that's why the outcome of this specific legal move by the NYT and whatever the judge decides about it is potentially so impactful.
Because it could set the standard.
It could set a critical precedent for how AI interaction data gets treated legally from now on. It might end up defining the privacy rights or maybe the lack of rights that you, the user, can expect when you talk to an AI in the future.
And the potential impact on users. If the New York Times does win this particular argument and the court enforces the demand, it's not just theoretical, is it? It's very real for millions of people.
Oh, absolutely. The scope is enormous. The source material really hammers this home. It would affect users across all account types.
So not just the free users.
Nope. The huge base of free users, sure, they make up the majority, but also paying subscribers, people with Plus accounts, Pro accounts, even business teams accounts. Basically, if you've ever used ChatGPT, period, you fall under the umbrella of users whose data the NYT wants locked down indefinitely.
Okay, so paint the picture. If the judge says yes, NYT, you get your order. OpenAI, you must retain all data indefinitely. What are the concrete consequences for me, for you, for those millions of users? What actually changes?
The biggest, most immediate consequence is you completely lose the ability to permanently delete your conversations.
Gone. That option just disappears.
Effectively, yes. If the demand is enforced, it means 100% chat retention for everyone. All conversations, no matter what they're about, quick factual question, or deep personal soul searching, would be stored indefinitely by OpenAI.
So the current policy of purging after 30 days?
Would be overridden by the court order. That mechanism for permanent deletion would just stop working.
So that delete chat button in the interface, what happens when I click it then?
Under this hypothetical court order, clicking delete would likely still remove the conversation from your view, make it disappear from your personal chat list.
Okay, so it still looks like it's gone to me.
Right. But it wouldn't trigger that background process for permanent system-wide deletion anymore. It would essentially become an archive this from my site button. The data itself would remain locked away in storage on OpenAI servers.
And available for?
Available potentially for legal discovery in this case. And, depending on the precedent set, may be discoverable in other court cases down the road. Users would totally lose that fundamental control they currently have, deciding when a conversation gets permanently wiped from the company's records.
This really brings it home, doesn't it? Back to you, the listener. Just imagine, for a moment, all the different things you might have discussed with ChatGPT.
Yeah, brainstorming sensitive work projects you haven't shared yet.
drafting difficult emails, exploring personal anxieties or health concerns,
Writing private journal entries or creative fiction.
getting an unbiased perspective on a tricky personal dilemma, asking questions you felt were too basic or maybe too embarrassing to ask another person.
Or seeking emotional support, exploring new business ideas privately before pitching them, getting help organizing deeply personal thoughts.
Exactly, all that stuff. If you had any expectation that deleting those chats meant they would eventually truly be gone forever, this demand directly challenges that.
It means that data, even if you hit delete thinking you were erasing it permanently, might still exist, still sitting on OpenAI systems, kept there indefinitely by a court order, and potentially accessible as evidence in this legal battle or maybe others in the future.
It really shifts the basic assumption about how permanent or impermanent our digital conversations with AI really are.
It's a stark reminder, isn't it, that delete in the digital world doesn't always mean gone forever, especially when the legal system gets involved, and especially in these new areas where privacy law just hasn't caught up yet.
And the source material we looked at, it adds another really critical layer to this whole complex picture. It suggests that, while both sides are talking a good game about important principles like copyright and privacy,
There might be other things going on.
yeah, that there are also significant underlying business interests really driving their actions.
Ugh, the motivations behind the curtain. That makes sense. The analysis in the document suggests that while the public arguments are framed around genuine legal issues copyright, privacy, the actions taken, might reveal different, potentially more self-serving priorities.
Priorities linked to their core business models,
Yeah.
like the legacy media company versus the cutting-edge AI firm.
Exactly. And in this view, user privacy kind of gets caught in the crossfire, becomes collateral damage.
Okay, let's try to unpack OpenAI's potential underlying motive beyond just wanting to protect user privacy in principle.
Well, the source argues that protecting their access to data, all data, including conversations, is absolutely paramount for OpenAI's competitive edge and their future development.
So,
Access to vast amounts of high-quality data, especially conversational data, is literally the fuel they need to train and improve their AI models. It's not just about scraping the public web anymore.
it's about how people actually use it.
Precisely. Understanding how users interact, what questions they ask, how they react to the AI's answers. That conversational data is incredibly valuable. They use it for fine-tuning the models, finding the weak spots, discovering new ways people want to use AI, and ultimately making their product better and more valuable commercially.
So, a court order forcing them to retain everything indefinitely and potentially making that data subject to outside scrutiny through discovery,
Yeah.
that could mess with their ability to manage and maybe even use that data for future AI training.
It could complicate it, certainly, or at least set a burdensome precedent for how they have to handle this incredibly valuable asset. So safeguarding that data pipeline, keeping control over it, is a massive business interest for them.
So while they frame it around AI privilege and user privacy principles, there's also a strong business case for resisting any court dictating how they manage their core data assets, especially user interaction logs, which are vital for improving their models and staying ahead of the market.
That's the interpretation offered in the source, yes. And then flipping the coin, looking at the New York Times' side.
What's their potential underlying motive beyond just protecting their copyright legally?
The source suggests their motivation, while presented legally as copyright protection, is really aimed primarily at preserving their own content monetization models, protecting their revenue streams in the face of this disruptive AI technology.
Meaning they see AI like ChatGPT as potentially devaluing their paid journalism by giving away summaries or key info for free.
Right, or bypassing their paywalls entirely. So this lawsuit is fundamentally a way for them to assert control over their valuable intellectual property.
And maybe force OpenAI and others into some kind of licensing deal, a compensation model for using their reporting to train AI or generate answers.
That seems like a likely goal, yeah. It's probably less about trying to stop AI development altogether and more about making sure they get a fair slice of the pie, or at least maintain control over how their premium, expensive-to-create content is used by these incredibly powerful new platforms.
Their whole business relies on people paying for access to their unique reporting and analysis. If AI gives that away, freely or cheaply, by summarizing their articles.
It's a direct threat to their bottom line, their very existence in some ways. So the lawsuit, including this data demand as a tool to prove widespread use of their content, is a really strategic move in that fight for economic relevance in the age of AI.
And the source's conclusion about this whole dynamic is pretty stark, using the phrase users caught in between.
Yeah, it frames user privacy as basically becoming collateral damage in this larger corporate tug-of-war.
A high-stakes fight between a traditional media giant trying to adapt and a leading AI company basically defining the future.
And the privacy expectations, the data control of the millions of people using these services gets kind of squeezed in the middle. The source suggests that neither party, maybe, is truly prioritizing user privacy above their own core business survival and growth strategies, despite what they might say publicly.
Which brings us back to why the source keeps mentioning the idea of regulation.
Right. The document seems to conclude that if we want truly robust protection for user privacy, especially as AI gets more personal and integrated into our lives, it probably requires more than just relying on company policies, which can change, or these reactive lawsuits between big players.
The actual rules.
It suggests that without clear legal frameworks, without proactive regulation that specifically addresses AI privacy, data rights, and what confidentiality means in AI interactions, user privacy might always end up playing second fiddle to powerful corporate profit motives and the intense competitive pressures within the tech industry.
So leaving it just to the market or individual court battles might not be enough to really protect the public interest here.
That seems to be the underlying message, yeah.
Okay, so bringing it back to the present moment. Where does this specific fight over data retention and the broader lawsuit actually stand right now?
Well, the main New York Times lawsuit against OpenAI and Microsoft is very much ongoing. It's still working its way through the legal system.
And OpenAI didn't just roll over on the data retention demand when the NYT asked for it in discovery, did they?
No, definitely not. They formally appealed that specific order. They are actively challenging the judge's initial ruling or indication that they should preserve all the chat logs.
What are their grounds for appeal?
Arguing against its necessity for the case, its massive scope, and of course, the significant privacy implications it carries for their users.
So right now, we're basically waiting for a higher court or the same judge to make a final decision on that specific point.
Yes, exactly. A final ruling on whether OpenAI absolutely must comply with the indefinite retention of all chat conversations is pending from the district court judge handling the case.
And that decision is being watched pretty closely.
Very closely. By legal experts, by the tech industry, by privacy advocates, because of the precedent it could set. It's a big deal.
And has OpenAI said anything about keeping users informed?
Yes, they have publicly committed to informing users about significant developments in the case, especially any rulings that might directly impact user data privacy or change their policies around conversation history.
Okay. So we're left with this incredibly tangled web, aren't we?
Yeah.
You've got a core copyright dispute, which triggers a legal demand for data, which then smashes into a company's privacy policy and what users probably expect.
Yeah, and user expectations about confidentiality in these increasingly sensitive AI chats run headfirst into the totally legitimate needs of legal discovery.
And layered over all of that are these powerful corporate interests, both sides fighting for control and position in this new digital economy.
It really is a perfect storm, isn't it? Technology advancing at lightning speed, user behavior shifting in unpredictable ways, legal frameworks lagging way behind, and high-stakes business competition.
And right smack in the middle of it all, for you, the listener, is that fundamental question. How much control do you actually have over your own digital footprint? Specifically, the data generated by your private conversations with an AI.
It really forces us to think about some huge questions for the future, doesn't it? As AI gets even better, more integrated into everything we do, our work, our personal lives, acting as assistants, creative collaborators, maybe even emotional sounding board.
Where should we draw the line on privacy and confidentiality for those interactions? Sam Altman's idea of AI privilege, even if it's legally shaky right now, it does put that essential question on the table.
Yeah. When you pour your thoughts, your ideas, maybe your vulnerabilities into a chat with an AI, who actually owns that conversation? Is it yours? Is it the company's property? Is it something totally new that needs a new definition?
And under what circumstances, if any, should that conversation ever be accessible to anyone else, to third parties?
Yeah.
Should a standard legal dispute like a copyright case between two corporations really be enough to force the retention and potential review of millions upon millions of potentially deeply personal user interactions, especially if those users tried to delete them?
And the fact that there's no clear legal answer right now, that lack of established clarity, it means these AI conversations exist in a very different legal space, potentially a much less protected space than, say, talking privately with your lawyer or having a therapy session with your doctor.
So does that mean our digital chats with algorithms are just inherently less sacred, less private? Or is it simply that the law hasn't caught up with the technology yet? It's a critical question we all need to grapple with as AI keeps evolving so rapidly, becoming an even bigger part of our daily lives and, in a way, part of our digital identities.